Good afternoon. Good afternoon. Thank you, Dr. Azad, sir, for having this great session here. Disclaimers first. Firstly, I do not possess a law degree. It's my first foray into the world of law. This presentation does not intend to hurt any sentiments of any person, place, or professionals, since there are a few names taken here and there. And these list of legal cases for ROP is illustrative. It may not be complete. So, talking about legal judgments for ROP, we've tried to put them in some sort of a chronological sequence, starting from the Mumbai case in Feb 2012. Compensation was 5 lakhs by the Maharashtra Consumer Forum. The next was the Ludhiana case in April 2012, 7.5 lakhs by the Punjab Consumer Forum. Then we had this landmark case, which Dr. Anand just spoke about, 1.8 crores in Chennai in July 15. This was the final judgment given. The next one was in May 16 in Delhi for 64 lakhs. And the last one was in Indore, right here, in September 16, which was 1.2 crores approximately. So we see huge numbers here, a lot of money being paid by, and all of these cases, the doctors have lost. Not one of them, the doctors have managed to win any case. So we'll go one by one, just look at the salient features of each case today. The first case was from Mumbai. Baby was born on November 7, 2007, 28 weeks baby. He was in the NICU for 24 days, but 7 months later only the ROP could be diagnosed at stage 5 in 2008 by a relative ophthalmologist. He had gone home. There's Dr. Jagdish Shah, who's a relative of his, and during that visit, he came to see this white reflex and ROP was diagnosed, just by chance. So obviously a case was filed against the treating pediatricians, and the allegation was failure to inform parents about ROP screening. Judgment was delivered 5 years later, in Feb 2012, for 5 lakhs. So the pediatricians claimed they had advised ROP screening, but the parents did not go to a retina specialist for it. They had no proof for this, though, and the parents filed affidavits denying the screening at all. On the contrary, the pediatrician's records somewhere showed eyes WNL written in one corner, and ROP was actually diagnosed 7 months later by a relative, as I just told you. So the court pronounced the following judgment. These are, I quote verbatim: failure of the accused to inform inherent known risk of ROP can be considered as their failure in their professional conduct, and such gross negligence amounts to deficiency in service on their part, within the meaning of Consumer Protection Act 1986. So lessons learned are, ROP screening must be advised, and this has to be documented that the screening has been advised. Casual statements like eyes WNL must be avoided. Coming on to the next Ludhiana case, baby was born in June 2001, 31 weeks, 1.34 kgs. The baby was in the NICU for 38 days, but ROP couldn't be diagnosed. 4 months later, stage 5 was seen in October 2001. A case was again filed against the pediatricians. Same thing, no information about ROP screening. Judgment delivered in April 2012. Compensation granted 7.5 lakhs. So in this case, apparently, ROP screening was done by an eye specialist at 8 days of age, and it was said there's no ROP. Further follow-up at 4 to 6 weeks of age, as the court found should be done by medical literature, was not advised. This, the court said, was the first deficiency. The second deficiency, the court said, was there was no documentary evidence of the above-mentioned ROP screening. Neither was there any documentary evidence of ROP follow-up being written anywhere in the case sheet. So again, the court stated there was gross deficiency in service on the part of the appellants, who forgot about this disease, which was so serious in nature that it made the infant blind for life. The appellants were duty-bound to indicate in the discharge summary mandatory ROP screening and follow-up. They were thus held guilty of deficiency in service again. Case number 2, this was. What lessons do we learn? Again, similar lessons to be learned. Documentation of ROP screening. And first, ROP screening immediately after birth is not enough. Follow-up is a must, should be documented and should be done. Then comes the famous Chennai case. Babies were born in August 96, 29 weeks, 1250 grams, stayed in the NICU for 25 days. But unfortunately, ROP was diagnosed 4.5 months later at stage 5, accidentally on a DPT vaccination visit in another city. It wasn't diagnosed in Chennai. Then a case was filed against the government hospital and the treating pediatricians. Again, the allegations were no advice for ROP screening. The first judgment which came in this case was 13 years later, in 2009, by the National Consumer Forum. This was 5 lakhs. So again, an appeal was filed, and then finally we see this huge amount of compensation being paid in 2015 in the final Supreme Court judgment. So no disclosure in discharge summary for screening or proof of preventive care being taken for ROP. No advice to visit a pediatric ophthalmologist. This is all from the judgment. I'm quoting the judgment right here. There was no proof that ROP was not known in 1998. The court again said, whether the consequences were foreseeable or not must be measured with reference to knowledge at the date of the alleged negligence, not in hindsight. Thus, ROP was reasonably foreseeable to the doctors. Review of medical literature and a report by the AIIMS Medical Board confirmed that ROP starts developing 2 to 3 weeks after birth. This is there in the judgment. So the court said there was no reason why ROP screening and accepted practice was not done. And the doctors were implicated, and this huge compensation was given. So this case taught us something very interesting, how they calculate compensations. It's a Latin term called restitutio in integrum. The aggrieved person should get that sum of money that will put him in the same position as he would have been had he not sustained the wrong. So it must compensate for the financial loss, pain, suffering undergone, and the liability to incur disability affecting future normal life. So they calculate this compensation in these heads. They calculate for past medical expenses, future medical expenses, compensation for mental agony, and of course, lifelong dependence and care. So the judgment, the sum which came, it had 6% annual interest for 23 years. That's what led to this huge amount. And another thing was they counted for inflation. So at that point of time, the RBI rate of inflation was 2%. So they added up everything and it came to almost 1.8 crores. So this is how the compensation is calculated. Coming to the next case in New Delhi, baby was born in April 2005, 32 weeks, 1,500 grams. Again, an ICU stay was for 28 days. ROP was diagnosed 8 months later at stage 5 in December 2005. Now this case is more interesting for us because the pediatricians as well as the ophthalmologist was implicated. The allegations as per the judgment were negligent care of the premature baby, and I am exactly repeating the words in the judgment, casual improper ROP screening by the ophthalmologist. The judgment was delivered 11 years later in May 16 for 64 lakhs. The hospital initially refused to give medical records to the Delhi Consumer Forum, which was actually not taken very well by the court. The hospital later submitted papers to the National Forum stating that ROP screening was done by their senior retina surgeon, Dr. Jha, at 24th day of life with no ROP. Parents were also blamed by the hospital of contributory negligence by missing follow-ups. AIIMS was actually asked for a medical report, but the court did not agree to their report, calling it biased in favor of the doctors, and biased because it upheld the contributory negligence by the parents. There was a scribbled note in the file in an illegible handwriting in one corner. It read like this: 26/4, Dr. SNJ, no ROP, review in 2 weeks. There were no details of ROP examination, who did it, how it was done, drugs and anesthesia used, details of pupillary dilatation, details of indirect ophthalmoscopy findings, or any other extraocular findings. I quote the judgment, no record means it was not done. The court in its judgment mentions Indian Journal of Ophthalmology, American Academy guidelines, NNF guidelines, etc. It unfortunately reprimanded AIIMS for its report and stated previous judgments to remind the AIIMS experts of their duties. Lessons to be learned: ophthalmologists can be equally held liable. ROP screening to be documented in meticulous detail vis-a-vis who screened, how was it screened, drugs used for dilatation, anterior segment findings, and you should always follow standard protocols which are published in journals, or as today Dr. Anand showed, standard guidelines available freely now. Published work and guidelines are given much, much more credence than the opinion of medical experts. The courts easily said the AIIMS people were biased. So always stick to the published word when it comes to ROP screening. The last case, the Indore judgment. This was a set of twins born in May 90, 1.04 kgs and 1.16 kgs, 28 weekers, 40 days in the NICU. 3 months later, August 1990, white reflexes were seen. Again, cases were filed against the pediatricians. Allegations as per the judgments were extra oxygen given and improper care. Judgment delivered in 2005 by the district court. Appeal was filed, and finally it went to the MP High Court. In 2016, judgment was delivered. The final amount granted was 1.2 crores. This has a little bit of detail, as I think we don't have the Indore talk separately today. The parents claimed that 28-week twins were given oxygen more than required during the 40-day NICU stay. The senior ophthalmologist at Chotaram Hospital, Dr. Parvani, quoted an old textbook chapter by Dr. Harsh Kumar, Shapiro, and Dr. Azad on ROP, which at that point of time said ROP is not possible before 32 weeks of age. It was also said that the first ROP case was reported in 1992. Both these claims by the doctors were not accepted by the court, and another eye surgeon, Dr. Madan Kalyani, deposed that ROP was known in literature since as long as 1951. The Indore District Court awarded 21 lakhs with 6% interest. The parents again filed an appeal in the High Court saying the compensation amount was too less, and the court did not consider the fact that the twins had lost their vision for life, could not marry, and their life would be hell. The court found nothing on record to conclude that the babies were actually born blind. It only needed to confirm whether the babies became blind due to negligence and lack of proper care. The courts again said, I quote, for a professional to be found negligent, either he did not possess the requisite skill he professed to have possessed, or he did not exercise with reasonable competence the given skill. On cross-examination, actually, it was proven that Dr. Jain knew about the need for ROP screening and its existence since 1990. There was also no record of the amount of oxygen actually given to the babies. So finally, it was proven that he was grossly negligent on 2 accounts. The first one was by not referring the baby to a pediatric ophthalmologist for ROP screening, and the second, the court said, was not mentioning the quantity of supplemental oxygen given for respiration. The compensation they granted was 43 lakhs with 6% interest from 93 till the payment is made. So again, it added up to around 1.6 crores. So basically, all these cases were against the doctors, and we as ophthalmologists probably should take home these messages. ROP work demands extreme caution, cannot be done casually. Eye surgeons should follow established guidelines for screening and meticulous documentation. Imaging and maintaining the records long term is definitely advisable. And one must have medical indemnity insurance because you never know when you have a bad day. And to sum it up, please pray to Lord that if you do have litigation for ROP, it happens as soon as possible after any mishap and not many years later. Because you'll never be able to pay the compound interest which it will entail maybe 20 years down the line. Thank you.